Good morning. Today is World Intellectual Property Day, which is celebrated every year on the 26th of April. This year, the theme is reaching out to the youth, to our young entrepreneurs, and we thought it would be feasible to explain intellectual property concepts to our school children. So let's look at the main forms of intellectual property rights. There are various forms and they can all coexist. We have trademarks, copyright, patent rights, design rights, know-how and confidential information, as well as trade secrets. So why do we want to protect intellectual property rights? Well, of course, we don't want to stay in Noah's Ark. Innovation advances technology. When we create new things, people want those new things. And through the wanting of the creation of innovation, we create commercial value. We can make something better than other people, and because it's protected, they can't copy us. So we exclude our competitors. And through innovation, we become the leader in the field of new development. So how do I create intellectual property? It's simple. It's all around us. It's the words we read, it's the pictures we see, it's the music we listen to, it's the ideas in your mind, it's the apps on your phone, it's the logos you wear on your clothes that appears on your phone, on your tablets, on your shoes, and many more. Some of them it's made available free, but remember, free doesn't make it yours. If the right belongs to somebody else, you may be infringing on that right. So why is intellectual property important? When you have done all the hard work to create something, don't you think you deserve a reward? IP is important because it's like a reward system. The reward is money. So inventions and new creations can form value, commercial value. This means that IP can be traded, sold, bought, or licensed. So, are adults the only people who are allowed to invent stuff? No! In fact, kids can be the best inventors because they have the best imaginations. So you guys can be inventors too. Alexander G. Bell said, always listen to children. They might have ideas we've never thought of. So if kids can be inventors, do we need anything special to become an inventor? No, to invent you need a good imagination and a pile of junk. So said Thomas Edison, and he should know. So let's look at the forms of intellectual property. We're starting with patents. A patent is a right that protects technology underlying innovation for a period of 20 years in a country where the patent is granted. A patent is a negative right, which means it grants you a monopoly right to keep others out from practicing the invention that you have created. It doesn't give you the right to carry out the invention yourself, though. Do you recognize these? Why? Because there's a brand. It's a trademark. These pictures that you see, these brand names that you see, are all unique names, designs, logos, symbols, or colors that are used by businesses to identify their products and services from the ones belonging to other companies, a clear distinguishing feature over the competition. Designs, on the other hand, protects the appearance of the whole or a part of the product, so it protects the aesthetic or the functional features of that product. And it could be in lines, contours, colors, shapes, materials, and products itself. It's very often used in combination with trademarks because it protects the underlying same principle. Design protection is quite important. It makes an article attractive and appealing, and therefore people would like to buy it. So it adds to the commercial value of the product and it increases its markability. Design protection is valid for 10 years for aesthetic designs and 15 years for functional designs in South Africa. A copyright is a law that gives the owner of a written document, a musical composition, a book, a picture, or any other creative work the right to decide what other people can do with it. Copyright laws make it easier for authors to make money by selling their works. Because of copyright, a work can only be copied if the owner of copyright gives permission. When someone copies or edits a work that is protected under copyright without permission, the owner may sue for the value of the violation. Most such cases are handled by civil law in the courts. But in more serious cases, a person who copies a work that is protected under copyright could be arrested, fined, or even go to prison. In most countries, there's no need to register copyright, and authors automatically own the copyright to any work they make or create, as long as they do not give the copyright to someone else. Copyright protection can be beyond the right of the lifetime of the copyright owner. It's generally valid for 50 years after the author's death, and in some countries it can even be extended to 70 years. There's an exception to the rules of copyright called fair use. This means that people can copy a very small amount of work to use in reviews or in search reports. An example of fair use would be in a newspaper, where writers quote several sentences from a copyright-protected work. Some people argue that copyright laws make it easier for people to make new works and think of new ideas. After all, if authors get to make money for their time, effort, and money they put in it, then they will want to make more works later and make more money. But others believe that copyright law makes it harder to be creative. Without copyright, other people could reuse existing works, and copyright law often stops that. As a solution to some of these problems, groups of authors have come up with an idea of open content. With open content, authors give permission to others to copy, change, and give away or sell their works, as long as they're following certain rules. Some of these rules are: if a person changes the work, or if a person makes a new derivative work based on it, they must give the original author credit. If a person publishes the changed or derivative piece of work, they must let others use it under the same for free license. Under some licenses, a person cannot sell the piece of work or use some money. As mentioned, your work is protected by copyright as soon as it's created and converted into a tangible form. Just because it's on the internet doesn't mean it's free. A common myth about the internet is that anything posted online can be copied or downloaded. It's not. Anything you see on the internet has the same potential of being protected by copyright, just like anything you see in a library or a bookstore. So, unless the copyright owner has granted permission or an exception or limitation in the copyright law applies, activities like uploading, mailing, distributing, and transmitting a whole or even a part copies of a copyrighted work over the internet may be a copyright infringement. So be careful. Another special form of intellectual property protection would be trade secrets. This would be an invention or innovation that is not protected by any of the rights we've just discussed, but has specific economic value because of the fact that it's kept secret. Think, for example, of the Coca-Cola recipe. Still today, nobody knows how to make that syrup. So is it easy to keep a secret, especially a trade secret? What does it mean when it's a trade secret? It is important that you do not disclose it on a public forum, so anything that's disclosed cannot be protected. I cannot protect it as a trade secret when I tell it at a conference. I cannot protect it as a trade secret when I publish it in an article. The best means to do this would be to use a contract, and in the agreement you will set out what are the obligations and the rights for the party that receives this information, and also setting out the principles applied by the owner of the trade secret to make sure that it's protected. And remember, a trade secret has only value and protection if it is kept secret through proper means, either agreements or letting those who deal with the trade secret understand it's a trade secret. And of course, the secret must have commercial value, so it must have an economic value for the protector of the secret. An interesting aspect about intellectual property rights is that different intellectual property rights can all coexist and protect one type of product. Look, for example, at the iPhone here. The touchscreen of this device is protected by patent. The Apple icon is protected by trademarks. The slim design, the white and black design with the silver apple, and the layout of the phone is protected by design. The organization of the icons, the color and spacing is protected by copyright. So one product, different IPRs. Once we have protected our intellectual property rights, we would of course want to make money with it. We call that process commercialization. So we commercialize intellectual property rights through either selling it or leasing it, letting it out. The leasing and letting it out is called licensing. So when we license our intellectual property, we make a business arrangement with another party that does not own the intellectual property, in which we give them permission, which is called authorization, to temporarily use that right. A licensing agreement generates revenue. It makes us money. The money that you make through a license agreement is called royalties. We get different forms of royalties. They can be once-off royalties, which is a big bulk amount, or they could be running royalties, which is continuous payments that I receive over time. Many of the rights that you use, for example, on your phone, have underlying license rights. You don't always have to physically sign a piece of paper for a contract to be in place. Sometimes just by accepting the terms and conditions, by clicking in the tick box, you're accepting those rights and you are in fact paying for a license to use that intellectual property right. Thank you for listening. By now you know that there's much more to intellectual property than you originally thought. If you are interested in this subject, please follow these links and have a look at the videos and information that's available. You can also download an educational kit at the link below, Intellectual Property Rights on the TES Global Limited website. We hope that from now on, Intellectual Property Day and Intellectual Property World Day will have a very special meaning to you. And now in closing, I would like to thank those from whose material we have borrowed, the World Intellectual Property Organization, for making World Intellectual Property Day an annual remembrance. AliIS International for celebrating on 17 March each year Kids IP Day in memory of Patrick Terrio, who passed away of brain cancer. We want to thank Summerhill Prep School for the children's art that we were allowed to use, Shutterstock for making free pictures available, Pixabay for some of the content that we've used, Intellectual Property Creativity in Bloom for some of the pictures that we used, and of course the European IPO for some of the pictures and content that we've used in this. Thank you to those who inspire us to be able to carry the message of intellectual property forward. We hope that this excited you as much as it excited us. Thank you.